Okay, so you're live.
We're taking up S4 this morning. This is February 17th. And it means that we have until March 17th to cross over, which is 3 legislative weeks starting next Monday. So we are going to be under a lot of pressure to continue working on bills, but those that don't make it doesn't mean they weren't important. It means that we didn't have time to do a good job. And I think the most important thing is to make sure we get it right before we send it to the other body. So with that said, we'll take up S4, and our first witness is Marshall Paul, Defender General, Deputy Defender General.
Thank you, Your Honor. You almost gave me a promotion. Not a promotion I actually want, by the way. And I'm going to share my screen for the presentation. And I want to start by saying, let's see if that worked. Yes, it did. Let me see if I can get that into full screen mode. Do it? No, that doesn't do anything. Sorry, we'll leave it like that. Oh, there's a full screen button. There we go.
Wait, I'm sorry. No, that's my fault. Sorry, guys. There you go.
All right. And the reason I want to do a presentation, I want to start off by saying this is a bill that's moved very fast. It's moved outside of the normal process. And so really the last couple of iterations of this bill and other parties' suggestions for this bill, our office still has not yet had a chance to even comment on. You know, we're already sort of in the process of markup. So we're both here commenting on markup and commenting on proposals that we still haven't had the chance to address. And that's why I want to start by talking about the process. Whoops, that didn't start at the beginning. Get back to the beginning here. That's why I want to start by talking about process. And this committee has seen a lot of juvenile jurisdiction bills over the last several years. In the last 8 years, pretty much every year there has been 1 or 2, sometimes more bills dealing with juvenile jurisdiction. Every single one of those bills that this committee has taken up and moved on has at least passed through, if not originated in, the juvenile justice stakeholders group. And that's important because the juvenile justice stakeholders, juvenile justice as a whole, is much more complicated than criminal law. That's because we don't have the same history that criminal law does. It's purely statutory. It was created. There was no juvenile courts until they were written into statute. They have no common law history. And therefore, they developed in every state just the way that we developed them here, simply legislators sitting around the table writing laws. That means they develop differently in every state. So where, for example, I can walk into any state in America, and if I walk into a criminal courtroom, there's going to be some significant differences between Vermont practice and their practice. But for the most part, they're all common law jurisdictions. I'm going to be very comfortable seeing what I'm seeing, knowing what I'm knowing. Juvenile laws developed exactly the opposite way. Juvenile laws developed in different ways all over the country, and that makes it very complex. And that means that when we work on these on juvenile laws, we generally get together in the summer and in the fall. This pretty large group of juvenile stakeholders that includes everybody: prosecution, defense, judiciary, DCF, DOC, victims representatives, and there's even people I'm missing from there. I know we've had education there before, lots of people. And it's a really highly experienced group. Once we sat around the table, there's probably 8 of us at the meeting that day, and we discovered that between the 8 of us, we were coming close to 200 years worth of juvenile court experience sitting around that table. This bill is not like those bills. This bill did not come from that group, and it's a reflection of that. You can see in this bill that it was drafted by people who do not have experience in juvenile court, do not have experience with juvenile law, and who do not have experience with juvenile practice. And so that's why I thought it was important to start right out with the process of how this came to be and why some of the stuff that, you know, normally when we come in here with a juvenile bill for you guys, we come in with something where that's pretty well laid out. We have areas of agreement that are usually pretty broad. We have areas of disagreement that are usually highlighted. So that there's like a little yellow version that says this is the Attorney General's version, a little red version that says the prosecutor's version, other people comment on it. It's usually pretty spelled out. Here we're coming in without any of that. Here, each party is just coming in, trying to comment on this very complex bit of legislation that's been sort of proposed and then amendments proposed to it. And I think that's part of what's making this a very complicated bill and a tough bill to get through, as you said, before crossovers, because it hasn't had the normal treatment where the experts go over it. And instead, we're basically trying to draft on the fly here. And so
I would disagree with drafting on the fly. When Eric and I've got a lot of experience in juvenile, and we worked together in drafting this. And if you'll note, there were 3 exceptions to current Big 12 when the bill was introduced. And those are areas that I felt strongly we would have a debate about it. The administration's proposal for an extra 28 or so, perfectly legitimate. I didn't have any role in developing that list. The list that's in the bill was one that was developed with the prosecutor of Bennington, with the chief of police in Bennington, and others.
I understand that, and I'll get at the end sort of to where you can see that it is a reflection of only one small sort of slice
That
of
may
the
be, I
juvenile
just
law in
don't,
Vermont.
I
And
didn't
that's
take
what-
exceptions that it wasn't done with thought.
I shouldn't have said draft with haste. I should have said
I'm not that sensitive, Marcia.
drafted with a narrow.
But it was done with, it wasn't done with a whole group. We didn't send somebody out to come back in a year, because this problem ain't going away until we do something about it. We need to do something about it.
I agree, but I also think that this problem is very different in Bennington County than it is in other counties, and that's part of the benefit of that process when we get people together from all over the state, and we're looking not just at what happens in Bennington County, but what happens all over the place. And so I want to start out also by talking a little bit about, because I think some of the problem, there's been some confusion even in this bill about the differences between juvenile courts, adult courts, and youthful offender. And so I wanted to start out with a really brief history of juvenile courts. Juvenile courts didn't exist until the 1800s, so basically 1900s. Before that time, there was no such thing as a juvenile court. We've had criminal courts going back, in our current form, at least to the 1200s, the Magna Carta, and really, in a lot of ways, going back to Roman law before that. Before that time, before the invention of the juvenile court, children under 14 could be prosecuted. Children over 14 could be prosecuted for felonies, but children after the age of 14, even after the age of 14, there were serious limitations on what children could be prosecuted for. So unintentional misdemeanors couldn't be prosecuted until age 18, and any offense of inaction, like misprision of a felony, couldn't be prosecuted until age 21. The juvenile courts were not designed, it's often presented as if they were designed to sort of keep kids out of adult courts. That really wasn't what they were designed to do at all. And in fact, juvenile courts did not have jurisdiction over the serious felonies that kids were going to adult courts for. Juvenile courts were designed to take the misdemeanor kids who were otherwise not being prosecuted at all and to provide some sort of accountability for them. And so those first juvenile courts acted sort of as super parents. They didn't really act as courts at all. If you went into them today, you wouldn't recognize it as a court. There was no lawyers, there was no evidence. There would be, the police would bring a child off the street and say, we caught this kid doing whatever, and the judge would say, you're going to the reform school for however much time, or the industrial school for however much time. 1967 was when the US Supreme Court finally said you can't treat kids like that. If you're going to be restricting kids' liberty and punishing them for offenses that are essentially criminal, you have to give them most, but not all of the rights that you give to criminal defendants. And that gets us to the sort of current state of the law, where we have juvenile court. Juvenile court is its own thing. Juvenile court exists separate from criminal court. It's not a criminal proceeding. There's no criminal record. It's not a public proceeding. children who go through juvenile court are not put in adult facilities alongside adults. There's a focus on rehabilitation and restoration rather than punishment, and they're age limited, and they didn't exist in common law. They're purely a creation of statute, which means the courts are much more limited in what they are allowed to do because they don't exercise what we call equitable authority, which is the authority that courts exercise in common law. Adult court is more traditional. Proceedings are public, they result in a criminal record. Those convictions can result in incarceration in an adult prison. The focus is on punishment, retribution, and deterrence rather than rehabilitation and restoration. And our criminal courts really today look in a lot of ways the way they did in 1215 when they signed the Magna Carta. It was basically like it's the same structure. And that is all just to say that these are two very, very different things, which gets us to the question, of course, so what's youthful offender? Where does youthful offender sit in that spectrum? And that's where there's a lot of misunderstandings happen, because a lot of people look at youthful offender and they presume that because it happens in juvenile court, in front of a juvenile court judge, it is in fact juvenile court. It's not. It's an adult criminal deferred adjudication program. What I mean by that is it's adult in the sense that if you violate your probation, there is a conviction entered in adult court. It is public record, and you get sentenced and punished like an adult. And for those reasons, the Sixth Amendment says that it must be adult court. And that's why, for example, when a youth wants youthful offender status, the first thing they have to do is waive their right to a jury trial and waive their right to a public proceeding. If it was juvenile court, they wouldn't need to do that because juveniles don't have a right to a jury trial and they don't have a right to a public proceeding. So that youthful offender status is really actually something that's pretty common in the rest of the country. It's an adult deferred adjudication status. In Vermont, we use deferred sentencing instead of deferred adjudication, but it's a similar idea. You essentially find if someone has committed the offense, and you say, rather than punish you right now, we're going to give you a chance. We're going to give you some conditions to abide by. And if you can abide by those conditions without screwing up, you won't get sentenced. You won't get that adult punishment. That's exactly like a deferred sentence. The only difference is we use juvenile court as a venue to keep it confidential, because confidentiality, particularly for juveniles, is a really big benefit. These are the people who are just in the job market. These are the people who are having the hardest time finding jobs in the first place. These are the people who are trying to emerge out into adulthood and find housing, all of which is very hard to do, even with a minor criminal record. So that gets us to the ping pong problem. We've talked about the ping pong problem in the youthful offender, and I don't think there's been a really clear explanation of what it is. And so this is a chart that I made that sort of explains who goes where in the court system. And really you have to divide it out into two different columns, or a column and a row, one for type of offense and one for age of offender. And as you can see, children as young, from 0 to age 10, there's only one way to wind up in any kind of court at all as a delinquent, and that's if you commit the offense of murder. From 0 to 10, you can be charged as delinquent with murder. Any other type of offense you cannot be charged with. But I put in parentheses the words chins, because honestly, when we have kids who are under the age of 10 who are committing serious offenses, it's not as if there's no government interaction. It's not like the government just says, oh, we got a 9-year-old out committing arson, we're not going to do anything about it. They treat that instead as a child in supervision, a child who's being neglected and not properly cared for. And so there's still a full range of responses to that, but the justice system response isn't there. Starting at age 10, you can go to juvenile court for any offense. Any offense you commit, you can be charged in juvenile court. Starting at age 12, you can commit offenses. If you commit murder or any other big 12 offense, you can be transferred to the adult court between 10 and 14, or 12 and 14. If you're between 12 and 14, your big 12 case will start in juvenile court, but can be transferred up. That's where we start to see the ping pong problems. these ones that I've highlighted in yellow, these are the areas we get ping pong problems. The other one, obviously, is 16 to 19-year-olds who commit any non-Big 12 felony. Those are cases that start in the juvenile courts, but then can be transferred to the criminal court. And here's what happens when that still doesn't tell you what the ping pong is. So I wrote out a little example of what it is, and I'll try to explain it as sort of quickly as I can. Let's say you've got a kid named, we'll call him Biff, just from Back to the Future, and he lights a porta potty on fire. And I use that as an example because it's a felony arson, but it's also something that I have represented way more kids than I ever would have thought of for lighting porta potties on fire. It seems to be a thing that kids do. I don't know why. I never had a compulsion to do that when I was a kid, but I had all kinds of things. I got in all kinds of trouble, but never that one. But burning a porta potty. So, and let's say that because Biff has a history of being Biff, we remember Biff from Back to the Future, the prosecutor decides that Biff should be given a chance to rehabilitate himself, but that he should have adult prison hanging over his head if he can. That this is not, that Biff should not be treated as a juvenile, that Biff has been in enough trouble and demonstrates enough maturity and enough sophistication that he needs to be treated in some way that's much more significant. The prosecutor has to move to transfer that case to the criminal division, which they can do because it's a felony and because Biff is 16, so he fits in that bottom right yellow box. And they have to go through an entire process to determine whether or not Biff should be moved to the criminal division. And that would be a process that would include looking at the severity of the offense, the harm that is done to victims, the Biff's maturity, Biff's social upbringing, supports Biff may or may not have in the community, ties Biff may or may not have in the community that might assist in his rehabilitation. There's a long list of factors that judges look at, and it's not an exclusive list. They're allowed to look at any other factors in addition to the ones they're required to look at. And then, so let's say that the judge decides, yes, I agree, Biff has been too much trouble in the juvenile division. We're transferring him up and treating him like an adult. But everybody also agrees that Biff is a 16-year-old kid and that he would really be better supervised by a juvenile probation officer receiving the services of TCF rather than an adult probation officer receiving the services of TOC, because those services are actually more attuned to Biff's developmental stage. Then the next thing that has to happen is there has to be a whole other hearing where somebody, presumably Biff, has to move for youthful offender status. And they go and they do almost the same exact thing all over again, where the judge sits down and thinks about, they put on evidence, and they think about Biff's maturity, the type of harm that he caused, the damage to the victims, et cetera, whether or not public safety can be protected. And they decide, okay, Biff can go youthful offender. Now that is a long and complicated process just to get to a point that probably most people in the courtroom knew that they were headed from the beginning. And that's the ping pong problem. And it is a real problem because what I teach all of our attorneys is youthful offender is a high risk, high reward status. We try as defense attorneys to make it so that our clients are never in the position of what we call being sentenced open, meaning that the judge is able to sentence our client to whatever sentence they want within the range. That's why we have 95% of quick cases in Vermont end in plea deals, and that's why. It's because we work with the prosecutor and we agree, let's narrow the range or even agree on a set range, but often narrow the range so that my client's exposure isn't so great. We can go to the judge and make a sentencing argument as to why my client deserves such and such a sentence without risking that high sentence. Now, why I call youthful offender a high risk, high reward status is if Biff screws up, let's say Biff gets youthful offender status, if he screws up, he goes up to the adult court, not to start a new process where we start to negotiate about a plea deal or anything like that. He goes up for an open sentencing. For him, it's as if he walked into court on day one at arraignment and pled guilty, which if my clients come into court and try to plead guilty at arraignment, I ask for a competency evaluation. Seriously, I do not believe that people almost ever, there's a few cases, out-of-state DUIs, things like that, that make sense to resolve very quickly. But there's very few cases where I think that when my clients are making a decision to plead guilty at arraignment, that it's actually a competent decision where they've had all the information they need. It's a really sketchy thing. So the point is just to say that getting youthful offender is not some sort of a gimme. It really is a very high risk status to get. And that's why we always teach our attorneys that the enemy in these cases is time. The more time passes before you get your client into those rehabilitative programs, into therapy, into services, the more likely they're going to fail youthful offender and wind up getting sentenced. And that's why we're very supportive of coming up with a plan that would eliminate the ping pong problem. Now, the ping pong solution that I propose essentially acknowledges that the evidence at a transfer up hearing is actually really similar usually to the evidence at a transfer down hearing.
Yeah, that was handed out. I think it's on the
Okay.
site. Yeah.
It's on the web.
It's on, I think, yesterday's documents. And that is, they're considering very similar questions, just from different directions. On one side, they're questioning, is this person so risky or violent? Are they such a danger to the public? Do they have such a low chance of rehabilitation that they should not be in juvenile court and should go up to adult court? Or on the other hand, they're considering the same factors, but the question is, should they go down to juvenile court? Under the current law, there has to be two separate hearings, often held months apart, just to reach the eventual goal of sort of, ping pong the person from juvenile to adult to YO. My proposal is to combine the hearings, to allow when a prosecutor moves to transfer a case up to the criminal court, for that hearing to take place, for the evidence to be heard, and then for the judge to be able to move immediately to what we call a youthful offender consideration hearing, to take judicial notice of all the same evidence and findings that the judge just made in deciding to transfer the case up, and use that same information to make a decision as to whether it should stay up or be transferred to youthful offender. Now, one of the things that's important about that is you can't just do a straight transfer. You shouldn't just do a straight transfer from juvenile court to youthful offender. And that's because juvenile court, as we've said, is juvenile court, and youthful offender is an adult status. In order for somebody to be brought from a juvenile court into an adult status, they have to have, there's some due process that has to happen. It was laid out in a US Supreme Court case called United States v. Kent, preceded in Ray Ball, which was the 1967 case by a few years. And it said you can't do this with no process. There has to be due process. There has to be criteria applied. And so that's why our position is, since they have to do it anyway, they have to have a hearing, they have to apply these criteria, just make it efficient and allow them to use that same evidence and those same criteria to make the youthful offender determination as well. Now, the state proposed a different version. The state proposed something that would essentially scrap the youthful offender system and take those cases that we would think of now as youthful offender cases, hold them in adult court, but seal the court and hold them in a confidential adult court. And this is another one of those places where, it really reflects the fact that this was not done. This process didn't go through the juvenile justice stakeholders group, where the people who do this work on a daily basis, talk about these things, because this is something that's already been tried. Connecticut tried.
You're talking about the administration's proposal.
The administration's proposal, and
I want to make clear between the state's attorneys and the administration.
And I often have trouble making that distinction, because I think at one point in your testimony, and I would certainly apologize to
I
State
think
Attorney
Erica
Marthage.
was more towards your.
My recollection was, in listening to the testimony, was that State Attorney Marthage disagreed with my proposal and supported the state's proposal. But their proposal was essentially to move to a system of sealed criminal court. If that had been run through the juvenile justice stakeholders group, somebody would have stood up and said, oh, Connecticut did that back in, I think it was 2014, and it was found completely unconstitutional and they had to throw it out the books. Connecticut did exactly that. They were dealing with exactly the problem we were dealing with. How do you deal with this group of what we call emerging adults, these people in the sort of 16 to 25-year-old age range, you know, and how do you do something that allows them, you know, provides accountability, but also protects their confidentiality. And the Hartford Courant, the newspaper, sued the state and said you cannot seal a criminal court. It's a traditionally open forum, and you can maybe seal it on a case-by-case basis, but you can't seal it for some blanket class of people. Like you can't say criminal court is always closed for people under 22 or for people whose cases were transferred from the juvenile court or anything like that, because that's not a case-by-case determination. The only way that you can seal a criminal courtroom is on a case-by-case determination, which they do in certain cases for example, sensitive witness testimony in a child sex case, things like that. So this proposal is literally identical to the Connecticut proposal, which was held unconstitutional by the Second Circuit, which is our circuit, that binding precedent in our state, you know, just recently. So
All I want to do
yeah,
is what we did in the beginning. Back in the day, we didn't have youthful offender status. So we invented it, but we didn't have enough youthful offenders to create a facility and a whole system like some states do. But we looked at Colorado and a few other states. The advantage was you had supervision from DOC and DCF. You had the services at the time. I'm talking now at 1996, 7, somewhere in there.
99.
99.
I think it was written in 97 or 98, but it took effect in 98.
Yeah, and our goal was to have dual custody. And unfortunately, the only one that used it was actually the Bennington courts. And some in Addison County were using it frequently, but most of the county stayed away from the youthful offender. So when I think it was 2017 or somewhere in there, we revamped the youthful offender and had wider use. But one of the things we did there that is the problem that I hope to solve is, back in the day, the same judge would hear the same case. So you didn't start all over again. The judge already knew the case. I mean, you more or less, you threw everybody out of the courtroom, drew the curtain, and you on to youthful offender.
Yeah.
And that's what I want to do, is get back to that without making it so disadvantageous that the state's attorneys no longer use it again. So that was where the argument about the plea deal. And that was a problem before 17, is you had to make a plea. Guilty or not guilty. Everybody, if you're not guilty, you wouldn't get it. They do raise a good argument about treatment, and the people who, you know, refuse to admit their problems, it's difficult to treat them because, you know, if you're accused of a sexual offense, for example, difficult to be in sex offender treatment if you can't admit to the crime.
There's a lot of problems with that logic, though, and because I agree with you that it is difficult. Like you use the sex offender example, and that is the classic example, and that's the example that works. Then there's a lot of examples that don't work. For example, I often advise my clients to plead not guilty, even though they fully admit to the conduct they committed. It's just that my advice as their lawyer is that that conduct didn't actually break the law. Now, if the judge finds that it did break the law, my client is not going to be unamenable to rehabilitation. They don't think that they didn't engage in some wrongful conduct. It's just a question of, technically, was that a violation of the statute that was charged or not? And frankly, that's the way it is in most of these cases.
But to be blunt, the problem I want to solve, I don't want to upset the system so much that prosecutors don't use it. But on the other hand, if we can get back to the same judge, assuming we're in the same county, that's where the ping pong comes then, right?
And I think so. I think that you're talking about two different problems that are related but not the same, and I can address them both separately. The ping pong solution that I suggested does exactly what you say. Keep it in front of the same judge. You never even leave the courtroom. You finish with one, and you don't even have to draw the curtains because you're already in the juvenile court where the curtains are drawn, and you move right on to the youthful offender consideration hearing, just like what you proposed. Now, the question about requiring a admission ahead of time is different. That was something that used to be in the adult court, you were required to admit before you could even access youthful offender status. And back then, we would have years where, it was in any given year between 11 and 33 people would access youthful offender status. And it was because you were required to admit right up front. And frankly, a lot of the times the admission of guilt or innocence has very little to do with whether somebody is taking responsibility for the action or not. Guilt or innocence is a very legal concept. Taking responsibility, going through rehabilitation, going through a restorative process is very much a moral process. It has nothing to do with whether you plead innocent or not, or guilty. Guilty or not
So if
guilty.
we go back to the requirement, there'd be a willingness to, I think it was in your proposal, and it's in current law, the willingness to engage in treatment or whatever, I don't know.
In Marshall proposal?
Yeah.
I don't think it's in the proposal, it's in current law. The current law is that in order to get youthful offender status, one of the there's basically two criteria.
Amenable to treatment.
Right, it's in there.
Basically two criteria.
We
One
did that
is-
last year.
That's been since the very beginning. The two criteria have been, first, that public safety will be protected if the youth is given youthful offender status. And the second one, which I actually sometimes refer to it as a three-prong, sometimes we refer to it as one, and then 2A and 2B. And 2A is that the youth is amenable to treatment, and 2B is that treatment is actually available for the youth. Because it doesn't really matter if the youth is amenable to treatment, if there's no treatment provider to work with them. So that's already built in. Judges should not be giving youthful offender status to kids who are unamenable to treatment. Another interesting thing that happens in juvenile court that doesn't happen in criminal court is we have the ability under a statute called 5113 to change orders that have already taken effect. So for example, if the youth is granted youthful offender status and because they went in there and said, oh yeah, I'm amenable to treatment, I'm gonna be a treatment hero, I'm gonna be a rehabilitation hero. And then they walk out the door once they've got the status and say, screw that, I'm gonna refuse to engage in any of this. You can absolutely go back and move to modify that original order granting youthful offender status under section 5113, which allows to modify any order for a substantial change of circumstances, which somebody initially claiming they were going to be engaging in treatment.
I'm getting worried about our time.
And I have a lot more to go,
Well, I got
because we haven't gotten even to the administration's proposal to expand the Big 12 to the Big 60 something. What do you want me to do?
I would like you to, we went over it during markup the other day. There are some crimes which are currently Big 12, where the legislature has changed the crime and added, I think there was 4 or 5 of them.
That were enacted after the Big 12 was
Enacted
enacted.
after the Big 12, and we think clearly those should be added. One I think is aggravated murder, so.
Certainly, we have no problem with adding aggravated murder. There's some of them, again, like I told you last time, my
I
favorite.
think if you saw our list that we narrowed it down to,
So I
it would be
listened,
easier for you to comment.
I listened to the audio, and I had a very hard time telling what you had actually struck from the list and what you would add to the list, and that's why I did not come through with a line by line, and instead came in with just sort of a critique of the list in general
Understood.
and how it was put together.
Well, I would rather have you come back on the list of Big 12 after Eric has had a chance to post where the committee was at. You know, it's a straw poll, there's no decisions have been adequately made. But the the one area where I think the general agreement is what you just said you didn't have a problem with.
I don't want to listen that far because I listened to your whole conversation, and when I said I didn't have a problem with it, it's
No,
definitely a
where they
sad
came,
motor.
where we-
I want to be agreeing to that whole conversation.
Oh, no, I understand. There were 3 or 4 of the crimes that the administration
Absolutely.
added that were really, we are to toned down, but they're more serious, but less.
Right, and so I'll withhold my comments on that till I see the list.
Yeah.
Because there was some stuff on there that would have taken us, I mean, honestly, into places that nobody's ever been before, like there's no time in history that 2 14-year-olds stealing a candy bar together would be required to go to adult court, and that was part of the proposal. That goes back, back before the common law, it's never
Well, once Eric has the list, if you could comment on that, but if you want to continue on
Sure.
other areas.
Sure, so I'll jump to this and I'm gonna move through this quickly, even though this is my favorite thing in the world to teach about. And if,
We've been through lessons on this.
and if people are interested in more of it, I'm gonna give a brief one today, but I would also, I can let the committee know when I'm gonna teach my brain development class for the law class I teach at the law school, and I can zoom everybody into it, because this is the heart of why we do all of this and why a lot of the proposals that are coming up here.
Remember Denny Schiraldi?
I know many. But why a lot of the proposals that we're talking about here are really ill-advised and move in the wrong direction. And I'll go quickly. We know that adolescence is a period of where people's brains are changing a lot. And really what's changing in people's brains is what's so important. Because there's 2 systems that really matter. And that's your limbic system and your prefrontal cortex. Your limbic system is the stuff in the middle of the head, and actually, like your pituitary gland, your amygdala, all that stuff. And that's the parts of us that develop the earliest. Those are the parts that happen right from birth. From the moment you're born, your limbic system is activated and it's working full steam. And it's all the stuff that you don't have to think about. It's all the stuff that you feel without thinking. It is feelings like I'm angry, feelings like I'm in love, associations that you get when you smell something and it brings back a memory without you processing it. That's your limbic system. It also is how you experience reward and punishment. When you've experienced reward and punishment, that's your limbic system feeling good and bad. The other part, your prefrontal cortex, up in front of your head, is really what makes us people, makes us capable of really higher level cognition. It's deliberative thinking, it's logical reasoning, it's planning ahead, and it's regulating your impulses. Now, what's important about all of that is how that changes in kids. So when you're an adolescent, your prefrontal cortex is incredibly inefficient. It doesn't process well, it doesn't think well. They've done some incredible studies, and in fact, it's funny because a lot of the science, still little in science is truly new. But this is stuff that like we learned about in the 90s, because that's when they developed functional MRI machines. They actually developed in the 80s, but they didn't think about using them for this stuff till the 90s. And so they put kids, it was actually a lot of it was done up at Dartmouth. They put kids into a functional MRI machine and they asked them really dumb questions like, is it a smart thing to chew on broken glass? Is it a smart thing to swim with sharks? And they would look, and they didn't even care how fast the kid answered. They looked to see how fast the kid processed, and kids processed like 4 times slower than adults. They all reached the same answer. They know you shouldn't chew on glass, but it took them 4 times as long to process that. Later in adolescence, you still have that, oops. All right, it's still there, I lost it on my screen, give me 1 second here. There we go. Your prefrontal cortex has gotten better, but it still has a hard time communicating with the rest of your brain. Now, what that really means for kids is, it's one thing to think about, okay, is it really meaningful that a kid takes some number of milliseconds or milliseconds longer to decide that it's a bad idea to chew on glass than an adult does? No. But it's when it gets to more complicated questions like, a kid making a decision about, should I get in the car with these kids tonight? Should I put a gun in my bag when I go out tonight? Should I take a knife with me tonight? These kids are gonna go into the store and I don't know what they're gonna do. Should I go with them? They're a lot more complicated, a lot more socially driven, and that's where that slow prefrontal cortex processing leads to some really bad decision making. Same with limbic arousal.
Marshall, I'm sorry, I'm really hoping that you can get to, personally, really hoping you can get to the procedures that we're trying to reform. I feel like we're in a lecture about, you know.
I'll back all the way out of that. As far as the procedures we're trying to reform, I think I've said everything that I have to say, which is, you know, we are certainly opposed to the expansion of the Big 12. We'll talk about that when it comes to the specifics. We are in favor of a change to adjust the ping pong problem, but we are not at all in favor of proposals that seem to be pushed a lot by the administration and by the state's attorneys, which would grant a lot more discretion to the state's attorneys in terms of where to file. And part of the reason for that, and I want to get to, I will touch on this, is that that is where you get racism. Study after study going back to the 50s have shown that judges give similar Black defendants longer prison terms than similar white defendants. Despite similar rates of offense, Black children in Chittenden County, back when Woodside was open, were 700% more likely to be incarcerated at Woodside than non-Black children. In a 2018 Cornell UVM study showed that Black drivers in Vermont were 400% more likely to have their cars searched, even though they were 20% less likely to have contraband found in that car when they searched. In Burlington, when we're talking about transferring kids from the juvenile court system to the adult court system, the most recent statistics I had were from 2020, and 20% of the juveniles that were transferred from juvenile to adult court were Black, even though only 6% of the kids in Burlington are Black. Adding discretion to the system is what makes the system have racist outcomes. That's not just true here, it's been proven all over the country. And we see it in the data here. And that's why we're opposed to these plans where, like, in order to solve the ping pong problem, we would simply give prosecutors discretion to charge. What we're focused on is things, and honestly, I will say this much as well, is it's a real change from what we were in here just a few years ago here. Just a few years ago, we were in here hearing from DCF and the administration that the idea was to focus on the offenders, not on the offense, that we should be looking at risk tools and risk levels, and that looking at the offense was actually a really lousy way to decide how to treat kids, because we have kids who commit serious offenses but actually are very low risk and have really good community supports and are not at risk of needing serious state intervention. And we have kids who commit fairly low level offenses who are actually really highly at risk. And we have risk tools that flag that. And just a few years ago, we were in here with the administration and DCF saying, that's what we should be focusing on, is these risk tools, not categories of offenses, not saying we're going to broaden it and categorize children based on the offense they commit. And so it's a real change now. And part of the shock and part of my dismay at the process, which I've expressed here, to see this change not only in the collaboration, but also in the approach that we are taking to these kids. We're no longer looking at them as individuals. The plan is not to look at them as individuals. It's not to look at their individual characteristics. It's to decide, you know what, if you committed conspiracy to receive stolen property, you're an adult. You should go to the adult court. Your public defender can move to get you down from adult court, but that's where you belong. And frankly, that would put us in a place where we would go from being a leader in the world of juvenile justice to being somewhere behind the rest of the country.
Thank you. Any questions from Marshall?
I just got a quick one. The screen just went down on us here.
Oh.
Anyways, you don't have to pull back up. You said 20% of the juveniles transferred were Black, and only 6% of Burlington's. What are those hard numbers look like, Marshall?
I don't have them off the top of my head, but I could. I might be able to get it for you before I even leave here. I just have to pull them up, so I'll let somebody else testify. and I'll
That'd be great.
try to pull up that report. I got it all.
David Englander from the Department of Health is here. David, well,
I'm here, Mr. Chair. Good morning.
morning. Do you have testimony on this board?
I do. Thank you for your time. So good morning. My name is David Englander. I'm the Senior Policy and Legal Advisor to the Commissioner of Health, and I'm here to talk to the committee very specifically about Section 10 of S4, which concerns the community safety grant programs that was seated with the Department of Health. I think that the committee members have the proposal sent by the department to the chair a few days ago. I just want to confirm that you have it before I go on. The concern with the language as proposed.
Is it from Dave Englander?
Yeah.
Yes, it's supposed to. Do you want me to share the screen if I can find it?
You want Peggy to share the screen? David,
I'm sorry, Mr. Chair.
would you like to have Peggy share the screen so people can see your proposed changes?
If that's what the members would like, sure.
Yeah.
So I just want to very briefly, the original proposal of S10 would require that municipalities apply for grants that would describe with corroborating data how municipalities community has been impacted by an increase in violence associated with illegal drug use, gang activity, or human trafficking. And the concern is that that would actually be extremely hard to implement, that there are very few communities throughout Vermont that actually have access to the data that would actually be able to demonstrate that. So the intention of the proposal that we can walk through is to broaden the scope and to with the intention of meeting the needs of both the legislature's intention as well as the administration's intention of reducing violence in communities throughout the state. So you'll see that we slightly tweaked the language of how it's described. It's a community violence prevention program administered by the department, just as originally envisioned, but it's broadened to include municipalities or organizations, for the most part, nonprofit organizations, with the idea that the department would establish a guidance document in consultation with DPS and others, so that potential grantees would understand the parameters expected by grantees, with the idea that these things would focus on evidence-based or evidence-informed strategies for access to human services, public health and safety, and all focusing on collaboration with communities to reduce violence and substance use through data-driven projects. This is something that the department could actually implement, and we think that we could actually get money out the door, given a little broader focus and a little bit more flexibility.
Good. In B, about the middle of the paragraph, it says the Commissioner of Health will develop and publish guidelines in consultation with the Commissioner of Public Safety. Do you have an objection to adding the Executive Director of Racial Equity to that?
No, we would welcome that.
Any questions for David or any other comments? Thank you very much.
Thank you, Chair. Thank you, committee.
Jessica Barquist is our next witness. No, see. Hi, Jessica.
Good morning. Thank you for having me. Jessica Barquist with the Vermont Network. And thank you all for the invitation to testify again about S4. We have already been in to kind of testify on the bill as a whole. So I'm going to try to limit my testimony to what I understand are the committee's lingering questions regarding that list of additional crimes. But we'll just broadly say that as a whole, we understand the language related to juvenile justice in this bill will address some of the current procedural issues. But just as I mentioned in my last testimony, really want to reiterate that we believe the core underlying issue here is that there is not enough existing capacity or treatment options available in family court that creates accountability for justice-involved youth, and that this is really a statewide issue that should be looked at comprehensively. So we hope that the committee will return to that discussion around what is needed here to fully realize that vision of Raise the Age and create true accountability for our juveniles in the justice system. That being said, my understanding is that your questions are really limited to what crime should be added to that list in 33 VSA 5204. And broadly, we believe that most of the juvenile offenses should be dealt with in family court. But in looking at that list from the administration, we would be supportive of a few additions. The first one being the aggravated stalking. And we agree with the committee's discussion around aggravated stalking, but not stalking itself. Juveniles are, as you've already kind of discussed, they're still learning what is and isn't appropriate in their intimate partner relationships. And that's why we believe that only the more serious aggravating stalking should be included on this list. Also support the addition of the aggravated sexual assault of a child. And then the other one I wanted to talk about is aggravated domestic assault, both the first and second degree. We would support that one being included, but also agree that it's a little bit tricky in a juvenile population because not all of these crimes are necessarily with an intimate partner. And so if there was a way for the courts to distinguish and separate out those family violence cases to remain in family court, and the intimate partner violence to begin in criminal, that would feel more ideal for us. But unsure if there's a way to do that since they're all charged the same. And then really quickly, I know there were questions around the last one on the list, which for us in particular, which was the violation of a condition of release imposed by a criminal division. And I will say, just really frankly, I don't necessarily have an opinion here. I have some questions. I'm really curious what the administration's intent was in recommending this on the list, and trying to understand more about it. If there are already criminal conditions of release, it means that they're already somehow involved in the criminal division. And so I just want to know more about what those cases look like. It's not something that we have seen in our work or with our folks. So just have more questions there, I guess, than a recommendation for you. But kind of broadly, I would say that we don't necessarily think it's appropriate to treat a violation at a higher level than we would treat a domestic assault. And that is pretty much all I have prepped, but would be happy to answer any other questions that I may have missed from you all.
So I was told the council. Yes. Before the sentence. Yeah, Jessica, I'm sorry. Thank you. Any questions? Yes. Thank you very much for being with us. Next is an old friend, Jennifer Coleman, whose name I forgot yesterday briefly.
I did actually have a question for Jessica.
I'm sorry, it was a question for Jessica and I didn't see that.
No worries. Maybe I missed it, but the one other one I had on my list that we were hoping for your input was the violation of an abuse prevention order or violation of an order against stalking or sexual assault.
Yeah, so those are misdemeanor crimes.
Okay.
And like in general, I think we shouldn't treat a violation more than we would treat the initial crime itself.
Okay. Thank you. I'm actually being brought back to committee discussion. I think we already made that decision, and that's why you didn't weigh in. So thank you for reminding me.
Yeah, thank you. Jennifer Coleman.
Good morning, Mr. Chair. Good morning, committee. For the record, my name is Jennifer Pullman. I am the Executive Director of the Vermont Center for Crime Victim Services. And my old friend, I hope you aren't referring to age, but I am getting there. So thank you for giving us.
Sorry, to young. I'm getting deeper and deeper in trouble with you. And so, all I did was forget your first name yesterday.
No, I laughed quite loudly, actually, Senator Sears, so thank you. Again, I really appreciate the time to speak today, and I know that we were in for a more specific question, and I know this committee has not really heard from the center yet, and I'm not just in the happenstance, but I'm thinking I'll just spend time talking specifically to the issues versus doing the 3-minute overview of the center. Would that be most helpful, Mr. Chair?
Yes.
Well, just had some general comments on the bill, and with respect to some of the pieces that have been raised in the administration's proposal, I really want to thank this body, and especially Senator Sears, for his leadership last year on really passing through some amazing language and amazing bill that dealt with juvenile justice proceedings. And the way in which we now treat and hold victims' rights in delinquency and youthful offender pieces is far different than where it was. And that work, in terms of the right to be heard, the right to be notified, the right to even be present, the work that was done last year really puts the center in a different place than it probably would have been on some of these issues a couple of years ago, because there's not that stark difference between what a victim is entitled to in a delinquency case versus a criminal case versus a youthful offender case. So this provides me with a lot of comfort and the ability to really think about how we can limit and how we can thoughtfully expand, let's say, the Big 12 without completely creating something that swallows the intent of why the Big 12 is what it is. So our list is, or our recommendation is really going to be much more narrow and probably in keeping with the network. So again, I do also appreciate this. It's been raised in this committee when we create lists that creates the additional danger that, well, then why if this, why not this? And so we go down that potential slippery slope. So our pieces will be very limited with respect to the ones that are in the current bill. We support those and also support the change from language from dangerous weapon to a firearm. Back in my early days when I was a juvenile defender, I would represent children in delinquency cases. And I remember getting a case where this young woman was charged with assault with a dangerous weapon, and it said shod foot. And I said, shod foot? And it's because she kicked somebody with a shoe. And so that was considered a dangerous weapon. So I just want to acknowledge that I appreciate that limiting language that's proposed and then additional change. With respect to other crimes, and again, I'll be quick. We appreciate the fact that the direct file would eliminate some additional hearings potentially and see it as an option, not as a requirement. With respect to the assault and robbery causing bodily injury, again, we're not sure exactly on where the committee landed on some of these cases, but it certainly was something that caught my attention when we think about this, again, subsequently created crime that actually involves injury, but that it's not considered in the same way. So that would be something that we would want to consider adding, or at least finding some way to reconcile that difference. And again, it gets back to this whole piece. When we create a list, then we create this natural comparison. We would agree with the network on the aggravated stalking, but not recommending stalking. We realize that, again, neurologically, young people are in a different place, understanding the implications, but the aggravated stalking is a whole other different piece. And Stalking is a very difficult case to prove. Any prosecutor will tell you that that's probably one of the most difficult charges they bring and actually secure any sort of resolution on. And these are also very important cases in terms of considering conditions of release. On an aggravated stalking, the conditions need to have some teeth, and bringing that forward, this very serious charge forward through that process, which has these, conditions of release teeth, we feel is very important. Obviously, aggravated murder, aggravated sexual assault of a child. As Senator Steers had mentioned, this is again a newer crime. This was a piece that, speaking of old friends, that we were a part of together in terms of addressing the horrible murder of Brooke Bennett. And this came after that fact, and that should be added. We agree with aggravated domestic assault as well. We do have, again, this is the danger, this is the comparison, because we have aggravated assault and we don't have this piece. But this is, again, that elevated issue, and it doesn't require a direct file, it allows for it, and having those really important conditions of release that have some accountability, that aren't then being addressed in filming court, but having some of those pieces are in place when you consider its definitions of serious bodily injury and what that involves. These are very serious cases. And then I'll touch briefly on lewd lascivious conduct with a child. This is very interesting in terms of when I'm working with the people in the field. In that, certainly this is a very different crime than lewd and lascivious. It's not demeaning. It is a crime that has lifelong impacts on children who experience this. And I know that Senator Baruth and Senator Sears will probably recall Taylor Fontaine's testimony back in this committee on the earned time issue. So this is a very serious crime, and actually it resulted in a carve out. This committee recognized, as did this body, that lewd and lascivious with a child should not be considered for earned time retroactively. But interestingly, when child advocacy centers and special investigation units, these are cases that when the individual who is alleged to have perpetrated the harm, they would never rush to prosecute. A young person, when that allegation is brought forward, they want to find out the root of that behavior. There is no assumption that when a 13-year-old engages in that conduct with a younger person, that this is something that should go the criminal route. I think what complicated the analysis for them was that we're talking about the raising the age, and we're talking about older individuals and what that involves with respect to, again, potentially an 18-year-old and a 4-year-old. And I really just wanted to raise that as we move this bar, it creates a different consideration. It used to be really simple for them when the delinquency bar was different in terms of age, but now when they're thinking about what this involves, it changes that. And again, I don't have an answer because they didn't, but I just wanted to flag for you that when we change things, it changes what used to be a really simple approach for them. And I work for Prevent Child Abuse Vermont as the director of sexual abuse prevention programs. And we always considered that when a young person was alleged to have engaged in harmful sexual acts, that person needed to get treatment and resources. But again, it's changed a bit in terms of how we think about who is a young person based on the changing definitions. I would agree with Jessica Barquist as well with respect to the VCR issue that's raised in 29 of the administration's proposal. For us, I think the more important piece is to think about the issues that Attorney Marthage raised in terms of how we can make conditions ones that are followed and tracked by the court that has jurisdiction of the case currently versus that bouncing back and forth. That's not helpful for safety, and it's not, additional hearings are not helpful for victims, certainly when we're talking about a child victim. So for us, having it as an additional piece in the Big 12 is not as important as making sure that we address the issues that Attorney Marthage raised. That was all I had on the, with respect to the specific question. I don't know what the list is, and if it's possible for me to come back and specifically.
We'll try to get the list together for everybody over the weekend when we come back to that Tuesday. I think there's like 3 categories. One is the crimes that we mentioned that have come after the Big 12 was developed and not added to it, like aggravated murder. And then there's those crimes suggested by the governor, those crimes that the committee was looking at as possible additions. And then the 3 that were in the bill as introduced. I guess that's 4 lists.
Well, those would be our limited suggestions. And again, we are really grateful for the work that was done last year that really recognizes that victims should have rights in whatever different proceeding it is, whether it's criminal, youthful offender, or delinquency. So knowing that there's that additional level of transparency puts us in a different position today than we would have been a few years ago.
Administration. Any other questions for Jeff? Thank you very much.
Thank you all. Drive safely.
Thank you.
So I know you're supposed to stop at 10:15.
Well, we'll give you, how much time do you need?
As much time as you'll tell me. If you say 3 minutes, I can do it then. I really
How
seriously.
about 7 minutes and no longer? You need a 10-minute break.
Absolutely, absolutely. Whatever you say will work. So Tom Zone, Chief Superior Judge. I wanted to touch base on just a couple points, and I want to start off by saying policy. What my comments today are going to relate to policy that you're going to have to decide and the legislature is going to have to decide. But there are impacts, I think, in the judiciary and in follow through with cases for the litigants that I think it's important for you to understand as you develop that policy and decide on which policy you want to go forward with. So if you look on, I'm looking at the draft from 214 version 2.1 of S4. It's in section 6 on page 6. And I'll start with the easy one first. On line 6, this is the section that talks about who is now prohibited from having firearms. On line 6, it says, it's a category of people who it says has been charged with. I would tighten up that language because has been charged when? A month ago? 6 years ago in New Orleans? So I say that, not to make a joke, but really we need to make it clear. The federal statute, 920, section 922 of Title 18 says is under indictment for. So you might, Eric, I would suggest you might want to come up with some language that makes it clear it's active.
Didn't we have indictment for in the original language?
No, we don't have a indictment in mind, but we did
I had
have
suggested it's currently,
currently.
Yeah, we did have this conversation in committee, and we, I
but
think,
I like
agree.
it under indictment for better.
And we haven't, it could be under indictment or information because that would cover it.
Pending charge? Pending
That
charge.
works too. It makes it clear that it's something going on now and not if you look in the criminal record, it existed at some prior time. And
20 years ago, you had a charge for.
So the other sections I wanted to talk about are just above that on lines 2 and 4. Line 2 gives a subsection that says you cannot possess a firearm essentially if someone is the subject of a final relief from abuse order issued pursuant to 15 VSA 1104, which is our statute. This mimics federal law to an extent because federal law has an exception that I would call it, if you will, a workaround that people can go forward on. And the federal law prohibits it if there's a finding in the final order that a person represents a credible threat to the physical safety of an intimate partner or child, or explicitly prohibits the use, attempted use, or threatened use of physical force. And sometimes what parties can do is come up with agreements where they will have no findings and then agree to the order, it's a civil order, it's their order, and they agree that, well, we won't check these boxes. Because what does that do? It may allow someone to possess a firearm under federal law. So I point that out because I just want to make it clear, this is more expensive. You are providing a greater array of individuals who cannot possess a firearm. So even if someone says, even if the defendant and plaintiff agree, no findings, in other words, they're no determination of what occurred. And even if they agree that they don't want these terms, and the only term they want is stay 200 feet away, 300 feet away, that will prohibit that person. And that is a change from where we are now.
That's okay. So our effort, well, the committee needs to decide because our effort was basically to mimic federal law.
But again, federal has those two exceptions. I'm just pointing that out. I want to make it clear that you're expanding it policy.
In the list of who can't.
Correct. It's under 18.922 8 is a subsection. Next one is the subject of a final order against stalking. This is a significant expansion. Federal law does not provide this. And I want to just let the committee know, when you think of stalking and when the statute was enacted, I wasn't in this position, so I don't know what the legislature was envisioning would be stalking. It is that situation that at times where someone is chased or followed, those very scary and dangerous situations. There's also a different type of stalking that can take place under the way our statute sets out the definition. A majority, I would say, of what we see, and I've checked with the judges to make sure I have this right. One judge commented they can't remember a week without a neighbor versus neighbor case, because that's what we see in stalking cases. The two neighbors are arguing over a boundary, and one says, I'm going to do this to you, and the other one says, well, I'll do this, and maybe someone puts up something, and maybe they say, well, I'm going to beat you down. We see the neighbor cases. We see the tenant against tenant in an apartment building. We see the tenant filing against the landlord, saying they're coming here and threatening me. We see the landlord filing against the tenant. We see 18-year-old, 19-year-old girls who get orders against each other because they're arguing over a boyfriend. And these are the types of things that we see quite a bit with these stalking orders. And this will be a significant change, because oftentimes what will happen is both sides come to court and the party will say, sure, I'll agree I'll agree to an order without findings. I'll stay away. I have no problem. This is going to change that, we believe. And this will require significantly more hearings, because there's no incentive then for the individual, if they want to retain their hunting rights.
I believe there is a federal law, that intimate partner.
That's correct. That's our relief from abuse protections, our intimate partner, because an intimate partner.
Stalking
This section is different, because the intimate partner would be someone who has engaged in a sexual relationship, which would fit with our definitions under subsection 2 for the 1104. That's the final relief from abuse category. So that's where we capture that. This are two people who just live near each other. They're not intimate partners.
Well, so, okay. So domestic violence already covered.
Domestic violence is covered under relief from abuse. These are for people who don't qualify as.
Senator? Yeah, and we're gonna.
Yeah, so I hear what you're saying. And I worry that intimate partner doesn't actually capture everything we might want to capture. I think back to when I was a teenager and my mother's partner was stalking me to threaten. We didn't have that kind of relationship, but that was incredibly dangerous and absolutely would not want that, So I worry that the intimate partner stalking doesn't actually capture everything that is in fact incredibly dangerous behavior, in which a firearm would heighten that.
Well, if that individual had lived in your residence, they would have been a family or household member, and that would have been under our relief from abuse protections, which last year in the temporary orders you specifically made notice of for firearms and can be taken.
I think you've raised an issue that we need to look at on Tuesday. And decide whether to leave that in there or take it out, or how to further define it, to make sure that we don't get the neighbor against neighbor. Or the individual who was at the town meeting got into an argument with another while the other was filming, and they filmed each other, and then they ended up with each having stalking orders against the other.
And under this, if this went through, neither of them would be out trying to get a buck that fall. Well, with a firearm. Bow and arrow would be okay.
All right. Well, anyway. I won't get into their proficiency.
Thank you.
Thank you. I think you know what's done.
That